The House Judiciary will come to order. Madam Clerk, please take the roll.
Chair Breen.
Present.
Representatives Edwards. Carter.
Present.
Hope. Here. Arvet.
Here.
Devendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you. I will take a motion from Representative Carter to approve and adopt the minutes from the previous meetings. And I will also take a motion from Representative, I'm sorry, those minutes are now adopted. I'll take a motion from Representative Arbit to excuse Representative Edwards. And today we are going to be taking testimony on House Bills 4738, 4739, also taking testimony on House Bills 4644 through 4446. And we will also be voting out Senate Bill 56 and Senate Bill 236. And at this moment, the committee will go at ease.
Morning.
House Bills 4738, 4739, so Breen, Mincer, and then VAG.
The committee is back to order. We will now take testimony on House Bills 4738. Representative Breen, 4739. Representative Menser. Please proceed.
Thank you, Mr. Chair. These are two bills that we actually had last term that they passed fairly easily out of the House. They got through the Senate, and I was recently contacted by the Attorney General regarding these bills because there was a court decision that came out once again that expressed the need to do this. For these two particular bills, we are going to be taking action in order to protect witnesses and victims of crimes to make sure that they can stay safe and they know that they are going to be able to freely testify without fear from harm. I'm going to keep my testimony very short because I believe the Attorney General has a more eloquent way of explaining these bills. But Representative Menser, do you want to say anything?
Sure. I just wanted to say a couple of words as you're going to hear extensive testimony from the Attorney General. First of all, thank you to the House Judiciary Committee for taking the time to hear these bills. As Representative Breen, or Chair Breen, made clear, these bills are necessary to allow or a complete redaction of a victim's or witness's contact information from criminal discovery materials. Without taking these steps, there is nothing to reassure victims or witnesses that they should not be afraid of retaliation. The accused has a right to adequate defense, and these bills allow personal information to be shared if it is necessary to provide such a defense. But no one should have to choose between safety and their right to press charges against someone that has caused harm. Thank you for your consideration.
All right. Well, good morning, everyone. Thank you so much for providing me with an opportunity to address the committee on these very important bills. As Chair Breen indicated, I testified before in front of this committee in regard to similar bills in response to People v. Ricky Jack, which was a case where the Michigan Court of Appeals held that a prosecutor cannot redact witness contact information from police reports produced during discovery absent a showing of good cause. And at the time, I feared that this ruling would be extended to include victim contact information and personal information as well. And my greatest fears have now been realized in a recent case, People v. Antararium, a case where the defendant was charged with home invasion and assault with intent to do great bodily harm. The Michigan Court of Appeals has now held that The personal information of crime victims is discoverable in police reports and is not entitled to any heightened protection and must be disclosed to the defense unless the prosecution first seeks a protective order from the court where it must show good cause to redact that very sensitive information. Now, this ruling inhabits a prosecutor's ability to protect victims of crime, and it will necessarily have a chilling effect on their ability to prosecute criminals who harm others. A legislative fix to these rulings is required, and I would argue essential, and I ask that this committee does that by working to enact these bills expeditiously. Now, I've always said that it takes great strength and courage for victims to face their abusers or assailants. They are the most vulnerable individuals in our judicial system, and they deserve and require encouragement and our protection. And we know that many victims are afraid to come forward, particularly those who are victims of sexual and domestic abuse. A 2018 report from the U.S. Department of Justice, more than 2/3 of victims of sexual assault did not report their crimes to the police. And the National Sexual Violence Resource Center indicated an estimated 63% of sexual assaults go unreported. In addition, and I know this was brought up with Rep. Arbit's hate crime bills, more than 2.4 million crimes where defendants were motivated by hate, and crimes that were committed across the United States during a 5-year period. An analysis by the Federal National Crime Victims Survey, which interviews tens of thousands of Americans annually, indicated that the FBI only counted 30,000 hate crimes reported to local police. Only 12% of the nation's police departments reported any hate crimes at all to the FBI. Now, that doesn't even touch on all of the just, I would say, routine armed robberies, carjackings, assault with intent to murder, and homicide cases where the victims and witnesses refused to cooperate for fear of retaliation by defendants. And as a result, many of those defendants went on to commit more very serious crimes. These are barriers for victims and witnesses in reporting crimes. And unfortunately, these recent cases has made it exponentially more difficult for us to offer assistance to these crime victims. Now, again, by way of background and how we got here, Ricky Jack was charged with open murder and first-degree child abuse related to the beating death of his 4-month-old son. The prosecution redacted the addresses and phone numbers of the lay witnesses. And after a request for more information, the prosecution offered to contact each witness and to gain permission to provide the contact information or otherwise make available these witnesses to the defense for interview. And they did. They did do that. As I indicated, this ruling has been extended now, of course, to victims as well. And in People v. Antaramian, a case where in that matter the defendant was charged with home invasion and assault with intent to do great bodily harm, the Michigan Court of Appeals held that the contact information be discoverable to police for victims absent a specific protective order where the court, the prosecutor must show good cause to redact that sensitive information. And this ruling inhibits a prosecutor's ability to protect victims of crimes, and again, will have a very chilling effect. Let me just give you an example of the effect it's already having. First of all, it's causing unnecessary delays in prosecution because prosecutors are so fearful of turning over this information that there is no discovery that's being provided at all. Oftentimes, where ordinarily, the case would get started, and more often than not, the case could proceed to a pre-exam, then to a preliminary exam, then to various hearings, and then to trial without there ever needing to be this information turned over. But because of the Ricky Jack case, now we're seeing all these unnecessary delays where we didn't see them before. These new rulings cause a re-victimization of victims who are already scared, already petrified to report their crimes. And let me just tell you, I had a meeting last week. I was talking to a Saginaw police officer who told me that it's not just that witnesses aren't coming forward. When they do come forward, they're refusing to provide their contact information to the police. So the police officer will say, well, how am I supposed to get in touch with you if I don't have your contact information? And they'll be like, well, I guess I'll call you, because I'm not going to give you my information because I don't want my information going to the defendant. And so, in reality, how are you supposed to pursue that case? What are the police and what is the prosecution supposed to do? And again, I just want to provide here's just a very typical example, I would say. If you were to have a case where an individual goes in to a gas station, to a 7-Eleven, and, pulls out a gun, robs the cashier, maybe also shoots the cashier, you got an attempted murder or God forbid, even a homicide, and you happen to be a witness. You're in the store at the time. You take off, as anybody would, under that set of circumstances, but you've seen everything. Now, you got a choice. Are you going to contact the police and let them know that you're a witness and that you've seen everything that just happened and come to court and testify against that defendant? Well, if you know that this defendant doesn't know you, but now this defendant, it's not just that they're going to know your name. They're going to know your address. They're going to have your cell phone. They may have other identifying information about you. How likely is it that you're going to cooperate in that prosecution now? I would be scared to death. I don't know that I would do it. And that's the only way that we can ensure that people are convicted of crimes that they commit is by having that necessary cooperation. So the practice of redacting the addresses and phone numbers of victims and witnesses is a long-standing one. Again, I started as an assistant prosecutor in Wayne County 30 years ago. This is just routine. This is what we've done for years and years and years. We redact the personal contact information of victims and witnesses. And if a defense attorney needs that information, if it's part of the case, you simply go before the court and you ask for it. And most times that's not necessary. You just talk to the prosecutor who understands it's necessary, and the prosecutor provides it. If you have to, you go to the court. But that information was always provided. You rarely saw a problem with this practice. And again, any problems with it, the prosecutors withholding any information easily resolved by a motion before the court. There is just no need to create a process where personal information of victims and witnesses are indiscriminately and automatically published. And again, sometimes handed over to some pretty dangerous individuals. So, just a few cases that I'd like to share with you. These are just recent events where, just horror stories where you see that victims and witnesses' information has been shared with not just defendants, but also they can then share it with their friends and family members. The case of Tavion Spiller, who was charged and is awaiting trial for the murder of Darren Bowden. One of my special agents, a former Flint patrol officer, got into a car chase. The driver fled on foot. When she was towing the car, she recovered a gun and jailhouse letters, including an unredacted police report with all the witnesses and surviving victims' names and addresses. And the letter instructed the friend to track them down and, quote, handle them. Nicole Smith, assaulted and raped in 2015. Her attacker was never identified until her rape kit was eventually tested. In the meantime, he stalked her on Facebook and then murdered her. He then dropped off her 1-year-old son at a fire department and claimed that he, quote, found him wandering the streets by himself. Here's a case that's going on today, handled by my department in Wayne County Circuit Court. Involves Starkeisha Thompson, who was murdered by 3 defendants 6 days after testifying in court that one of them had carjacked her at gunpoint, and this was after the defendants obtained her information from unredacted discovery in the case and then tracked her down easily and then executed her. As I've indicated, participating in the criminal justice system as a witness or a victim is a scary proposition. But fortunately, This important legislation helps to remedy the obstacles created by these court cases. It helps to shield victims who fear their assailants, and it adds a layer of protection for their personal information. Requiring proof that the address or phone number of a victim or witness is absolutely crucial to the integrity of a criminal case. It discloses the contact information under a protective order, and it shields the information from falling into the wrong hands and being used for nefarious purposes. And these measures will go a very long way to stem witness intimidation, and it will show good faith support for victims and witnesses. This is the very role of the legislature on this critical issue of policy. Now, the courts have made it clear that where there's a question of policy, it is the legislature's decisions that control. And I can cite several cases, including People v. Watkins, McDougall v. Shantz. If a particular court rule contravenes a legislative declared principle of public policy, having as its basis something other than court administration, the court rule shall yield. Without these proposed protections, what will be the practical results of People v. Jack and Anterarium? In a nutshell, it's very easy. Again, a drop in prosecutions, and perhaps even more detrimentally, diminished trust in a criminal justice system that already fails to sufficiently protect victims. So let's not lose an opportunity here. Keeping victims' addresses, phone numbers, and other information is one way that we can support victims and witnesses without violating the defendant's rights to essential information as deemed by the court. The other thing I want to mention is, even in cases where we're not fearing an assault of a victim or witness, it allows them to be subjected to identity theft by providing all of this information to a person who already may be a not very trustworthy person. So this body has already demonstrated and committed, has been shown to commit protecting the personal information of victims of domestic and sexual assault by enacting, a few years ago, the Address Confidentiality Program. Now, as you remember, that historic piece of legislation garnered bipartisan support, places a duty on my office to build and implement a system where victims can participate in a program that keeps their address confidential from those who sought to abuse them. The Address Confidentiality Program is an extension of those protections that are afforded to victims in the Crime Victims' Rights Act. But how absurd to create circumstances where the victims are forced to move from their homes and go to another address only to have to enroll in the Address Confidentiality Program because it was the criminal justice system that provided their address in the first place in many of these cases. I mean, it just doesn't make any sense. Those notions contravene each other. Under MCLA 750-758, crime victims were first guaranteed the right to privacy protections within the criminal justice system, and those protections including keeping their work address, home address, and their work telephone number and home telephone number of the victim free from the court file unless the address was the scene of the crime. And in addition, Article 1, Section 24 of the Michigan Constitution guarantees crime victims the right to be treated with respect for their dignity and privacy. Same information was exempted from disclosure under the Freedom of Information Act. This body has previously recognized that victims need additional layers of protection from those who seek to do them harm, and this legislation is one more step to protecting victims and witnesses who are forced to participate in the criminal justice system. Now, transparency and open disclosure in the criminal justice process are essential, and my office supports due process and defendants having a fair and just trial, but these protections need not come at the expense of victims' and witnesses' privacy and safety. Fairness and justice should exist on both sides of the courtroom. And I just want to end with a phrase I picked up. My wife used to work at the Wayne County Clerk's office, and the clerk there, Kathy Garrett, used to have signs up, not for the public, but for her staff. And they would say, "The customer is not an interruption of our day. The customer is the reason for our day." Well, I would say that in the criminal justice system, victims are not an interference to our work. Victims are the reason for our work. And victims and witnesses deserve the protection that they need in order to deal with the crimes that have been committed against them and to ensure that they're not subjected to further trauma and further re-victimization. And that's what these bills seek to do. I ask that the committee consider these bills and then pass them expeditiously, and I really appreciate the time that you've given me to make this statement today. Thank you.
Just to clarify, nothing in these bills prohibits, in fact, I would argue that it is required that the prosecutor produce witnesses according to the approved motions. So this is not a situation where somebody's not allowed to confront their accuser. This is not that. This is simply about victim and witness protection. We do have somebody else testifying on Zoom, but I and everybody else up here stands ready to answer any questions from our end.
Thank you, Rep. Ring. I have a quick question. Prior to these court decisions, were defendants saying they didn't have adequate information to get proper representation because they didn't have this information?
So I can tell you from my experience. So I had 14 years working primarily as a defense attorney, mostly in Wayne County, but in many other counties around the state. And that was not a problem that I would say I almost ever had, certainly not that I routinely had. Generally speaking, you would get the discovery. In the event that there was information that was clearly relevant to the case, and sometimes it is, the witnesses or the victim's personal information sometimes, of course, has a nexus to the case. You can't try the case without that information. And in those cases, the prosecutor would provide it. If it was redacted, most often what I would do is I would just contact the prosecutor and say, I'm going to need that information because it's part of the crux of the case. And they would provide it. In the very rare instances, and I mean very rare, almost never, that the prosecutor was not cooperative, then I filed a motion with the court. The court, ordered that the prosecution turn it over, and then it was, summarily turned over. But it almost never happened to me, and I will tell you, I handled thousands of cases as a defense attorney, and again, not just Wayne County and various other counties as well. I can't remember a single prosecutor's office that I dealt with that gave me a hard time, or that created a situation where I felt like I couldn't properly defend my client.
Thank you. Representative Fink?
Thank you, Representative Carter. So I got a couple of quick questions. The first is, what was the basis? I don't think I've read the Ricky Jack case. What was the basis of the court's ruling? Was it based on a statute, a court rule, the Sixth Amendment? What was it?
It's a court rule. Do you want to? I'm sorry. I have Mitch Albers and Aaron Van Lingenfeld from my office. I don't know if one of you guys want to take him.
Yeah, there were the basis is there were two conflicting court rules in the Michigan court rules that basically outlined that one allowed for redaction of certain information, and then the second one outlined that police reports had to be provided unredacted, but victim and witness information was able to be redacted in the previous court rule, and so they were just read as conflicting, and the court determined that the second court rule would control for that information.
Thank you. So, I think we had a version of these bills last term, and I think I voted for them. At the same time as I'm kind of trying to do due diligence on this legislation as is before us now. It's always difficult in matters dealing with criminal defense because in this context, when we talk about cases where there have been actual, a witness getting murdered or something, obviously, but the whole idea of having robust protections for a criminal defendant is that we don't know if they're guilty beforehand or not. And so I guess I'm just kind of wondering, it seems to me that the same interest that generates something like the Sixth Amendment right to confront your accuser should at least, we should at least ask the question, who should the burden in this case be on? Because as I understand your testimony about the content of this Ricky Jack case, they're saying without a protective order, the prosecutor is obligated to turn it over, meaning the prosecutor, if it doesn't want to do it, would have to submit, would have to file a motion. And under the text of these bills, we would essentially put the burden of filing the motion to get the information on the defendant. And so it seems to me like really that's the entire question here. Under the case law, the burden's on the prosecutor to obtain particular relief from the court first. If we adopt these, the issue is still the same. It's just who has to file the motion. It basically bears the burden of persuading the court either to release or not release the information. Would you say that's a fair way to summarize it?
Yeah, I think so.
It is, but we would also note that, prior to the Ricky Jack case, which is only 2 years old, this was the current process. So all we are doing is going back to what the process had been throughout most of the state prior to that case that was, just a couple of years ago. So we'd be talking about 30 years of criminal procedure that had occurred up until the Ricky Jack decision had come down. So that would
Meaning that the process was the prosecutor would make a decision, and if that decision was going to be overturned, it would be by the defendant filing a motion in that circumstance.
or as the Attorney General outlined, through cooperation between the defense counsel and the prosecutor.
Okay.
I would also argue that victims and witnesses did not necessarily choose to be part of the criminal process, except to say that they are choosing to try to achieve justice. They were unwilling, victims here, obviously. So, however, the person who has been accused of the crime, if they do end up being guilty, they're the ones that I'd say caused the whole process in the first place. We need to protect the people that were unwillingly made part of this system. And the burden, I think, therefore, should shift to the defendant in order to protect them.
Although we're presuming that person is innocent. I mean, that's the question is, if we presume the person's innocent and we're putting the burden on that person, are we being fair with that burden?
Well, I would say this respectfully. When it comes to, again, we mentioned FOIA, right? Someone who's submitting a FOIA, say, to my department, could be doing so for a variety of reasons. But we still don't provide, say an individual has filed a complaint and they've provided a number of types of information about themselves. And, their name, their date of birth, could be their social security number. We don't just give that out to people for a variety of reasons. And so in the vast majority of cases, there's not going to be a reason for a defendant, a defense attorney, or anyone else to have a lot of this identifying information about the person. And I think it's a completely fair procedure for a defense attorney to have to say, well, I'm going to need that, and here's why, here's the relationship to the case. But in the vast majority of cases, and you could pick any kind of case that you want, and we could analyze it, but in most cases, why does the defense need to know that information about a witness or about a victim? And remember, of course, there's opportunities even prior to the trial, not just for the cross-examination of these witnesses in the event they're called at the preliminary exam. And remember, the defense can also call witnesses at the preliminary exam. It's not just the prosecutor who can do that. But remember, the way that things worked before is that the prosecutor was required to make this person available to be interviewed by the defense, and that was the process always. So it wasn't as though the defense didn't have an ability to talk to this person or to cross-examine this person. But again, just to provide all of that information in every single solitary case, is really terrifying. And we have seen, at least I've seen, a significant reduction in cooperation by not just victims, but also witnesses who just don't want someone who, again, yes, they're presumed innocent, but also they've been charged with a serious crime. And I think it's a normal reaction not to want to have whoever that person is, who might be a stranger to you, to have all your personal information when they know that you're going to be testifying against them in a court of law, potentially on a case where they may go to prison for many years.
Seeing no other questions, I just have one statement to make. As a person who used to be in charge of all the lineups in Wayne County for some years, trying to get a victim to come forward was hard. Witnesses were harder. And to do a lineup, they had to be assured that their identification was going to remain private, so much to the point that I would have somebody in their family go to the other side of the glass to ensure that they couldn't be seen. This had nothing to do with due process, innocence, or guilt, but it was a part of the process to make sure that we identified the right person. And we also protected the person on the other side until that time that they were able to go to trial, I guess. So as we see these being pulled away, I just say there's a need for them because people are already reluctant to come forward. So your information is, and as someone who's had their information stolen, we need to protect it at all costs. Thank you all for your testimony. The committee will now go at ease.
We are back. Thank you, Representative Carter, and Attorney General Nessel and staff for helping out, and Representative Menser. We have now Jessica Zimbelman from the Criminal Defense Attorneys of Michigan testifying via Zoom.
Good morning. Hopefully everybody can hear me. My name is Jessica Zimbelman. I'm a managing attorney at the State Appellate Defender Office here on behalf of SATO and the Criminal Defense Attorneys of Michigan. I'd like to thank the committee for allowing me to appear by Zoom this morning. CDAM and SATO are vehemently opposed to these bills, and I have three main points I want to make that might get to some of the committee's questions as well. First, prior to the decision in Jack, we polled local public defender offices, and about 50% of counties were actually already providing unredacted reports. So Jack was not a huge fundamental shift in how discovery operates in Michigan. These unredacted reports were being provided to defense attorneys. And I want to make clear that that's what the rules allow for, is the provision of the necessary information to defense attorneys. If defense attorneys receive unredacted reports, and as a good defense attorney should do, give that to their client, we are redacting relevant information from those reports before going over it with our clients. But Jack was not a fundamental shift in how a lot of counties were operating. But the Court of Appeals was correct, and then the Michigan Supreme Court denied leave to challenge that decision in Jack, that the court rules are clear where the burden lies. And that gets to my second point, that the existing court rule, Michigan Court Rule 6.201, strikes the proper balance between the constitutional rights of people accused of crimes to mount a defense and to allow the prosecutor to seek a protective order in certain cases. And there are a lot of constitutional rights of people accused of crimes and the people we represent that are at play here. First, of course, there is due process baked into the discovery rules, and that encapsulates Brady. Prosecutors can't keep relevant information or exculpatory information from defense counsel. Defense counsel is guaranteed this information under the federal constitution and the longstanding precedent of Brady. Of course, we also, as criminal defense attorneys, have a duty to our clients under the Sixth Amendment to the United States Constitution to provide the effective assistance of counsel. And time again, from the Court of Appeals and from the Michigan Supreme Court, that duty to provide the effective assistance of counsel incorporates the duty to investigate. And not just investigate the people, the witnesses, the circumstances that the prosecutor gives to you, but to actually do an independent investigation of the facts of the case and any people who might be involved. And I think of this kind of to give the committee of an example that might happen and explain how hard it can be to investigate a witness that's listed in a police report. Because while it's true that the prosecutor can make witnesses available, under 6.201A, they only have to make available witnesses that they've listed on their pretrial witness list. So there could be many people listed in a police report that maybe saw something happen, but won't be called at trial because the prosecutor has decided not to call that person. But defense counsel needs the information to be able to independently interview that person to see what they might have to offer. Because of course, our clients have not been convicted of a crime at this point and are presumed innocent. But let's say there's a witness in the police report, the prosecutor doesn't intend to call it trial, and his name is John Smith. No other information provided in this redacted police report. You can imagine how impossible that would be for defense counsel to find John Smith and find out what John Smith might have to say about what he witnessed or what information he might be able to provide in order to guarantee a fair trial. There is almost nothing more important when you're preparing for trial than building your defense by independently interviewing and investigating relevant witnesses. And the nature of an allegations made against somebody, there are horrific allegations made against our clients all the time, but that does not diminish their protection under the Constitution, under both the Due Process Clause, the Sixth Amendment, and the obligations of the prosecutor under Brady. So the existing court rule that we've had for a long time establishes that balance, where we have the information that we need. And then if the prosecutor in a specific case is worried about this information, then they can seek a protective order. Because the bills as drafted right now, as we've discussed, flip that burden and put it on the defense attorney. But not only does it put a burden on the defense attorney, that attorney might have to reveal trial strategy, privileged discussions between the client and the attorney, in order to get this information that the prosecutor has at their fingertips. So the prosecutor does have the constitutional burden to prove our client's guilt beyond a reasonable doubt. And that's why the burden should stay as it is and has been for years on the prosecutor to seek a protective order in certain cases. And the last point I want to make, it's a little bit almost theoretical, because Ingham County Trial Court, in their Jack opinion, saying that the prosecutor needed to provide these unredacted reports, mentioned that it's constitutionally problematic for the prosecutor to control access to witness information. Because that's what's going on here, is that the prosecutor is attempting to shut the door on defense attorneys by not giving them information they have in their possession, requiring defense attorneys and investigators, if a defense attorney or public defender office is lucky enough to have an investigator on staff, to go out and find John Smith in order to meet their obligations under the Sixth Amendment to their clients, when the prosecutor has that information at their fingertips. So these bills are not necessary. We have the right rule right now to provide this information to defense attorneys who are officers of the court and treat that information with the respect that it is due. And I also want to point out to the committee's attention that there has been a proposed court rule change after the opinion in Jack, and that's administrative file number 2021-29. And that would allow for the redaction of address, telephone, or cell phone numbers, or protected personal identifying information found in Michigan Court Rule 1.109 D9A. And the court heard public comment on that in November and have yet to issue their decision. But one thing that SATO and CDAM suggested was that perhaps when we made public comment to the Supreme Court, is that maybe there can be redaction of the identifying information listed in Court Rule 1.109, but that we still have access to address, telephone, or cell phone number. Because that is the basic information we need to perform our constitutional obligations to investigate and to protect our clients, to make sure that their constitutional rights are protected at trial. I am happy to answer any of your questions at any time, but the basic summary is that our existing court rule works. It strikes the proper balance. It protects the constitutional rights of our clients, and allows for this information to be protected under a protective order, a process that the courts are very familiar with. Thank you.
Thank you, ma'am. I appreciate your testimony. I certainly understand your argument, but I just want to be clear, should these bills be enacted, there's nothing that prevents you from filing a motion with the court to request John Smith's info, correct?
That is correct, although that would be a strategy call for trial attorneys, because to make that motion, you have to reveal to the trial court and to the prosecutor your trial strategy.
And if that motion's
Because-
granted, then there's nothing that would, then they are required to produce this information in order for you to put on an adequate defense, correct?
That's correct, but making the motion in and of itself, because the requirements under the bill are so strenuous of what a defense attorney would have to show to get the unredacted information, I'm saying that by making that motion, you might have to, in order to get the information that is there, you might have to reveal your trial strategy or reveal client confidences to get information that the prosecutor has at their fingertips.
Okay. And
Defense attorney.
as far as the court rule goes, the legislature is not in charge of amending that. We can enact this policy, but as far as what we can do to protect victims and witnesses here, the legislature doesn't have a role in changing that court rule, correct?
No.
Okay.
I was offering that as an example of a possible middle ground to redact some information, but not the name, telephone, or cell phone number.
Okay.
Or address.
As I've indicated to other stakeholders and to your organization, we aren't voting on this today. I'm always open to discuss possible changes. Just so you know that is a door that is open. Representative Fink, you have a question?
Yes, thank you, Madam Chair. So I want to think about, I guess, what if there were to be some kind of an alternative. I mean, my assumption is that you agree that the safety of witnesses, particularly those who turn out to be victims, but of all witnesses, is critical, and the obligation is on the prosecutor / police / court / the state to keep these people safe. And so I guess my question would be, assume not just in the instant case there's an allegation of violence, but say you have a person who has been convicted a couple of times of domestic violence and is charged with a violent crime again. So you have a good reason to believe this person is willing to commit violence because we've convicted him a couple of times. And the victim or witness in the instant case, wishes to be protected, and the defense thinks they need the information. By what method can the court in that circumstance, what can the court do that would actually meaningfully protect the victim or witness in that case? You understand my question? What would an alternative be?
Well, I don't think we need an alternative. And the Michigan Court of Appeals, in the recent opinion that the Attorney General referenced, John Antamarian, acknowledged that the existence of the protective order that are in the current rules in a specific case, like the one you mentioned, those would be specific facts about a specific person that might warrant the court entering this protective order. So I don't think we need an alternative. We have one that the Court of Appeals has acknowledged is there for a reason. And I, from my experience with protective orders, how I have seen them as an appellate attorney is when I am reviewing the forensic interview of a child, when there's been a CSC conviction. The courts routinely, I have to see that information as an appellate attorney. But they will give it to me with a protective order that says, Jessica Zimbelman, don't distribute this, don't copy it, don't show your client, et cetera, et cetera, et cetera. So that process is well established and has protected children in that situation, and would do the same in a specific case that warrants it. And I think the Court of Appeals opinion, and we can get that to the committee if they don't have it, but in Antamarian, which was just issued on May 11th of this year, talks about how generalized fears about protecting victims aren't enough. But if a prosecutor can show specific things that would warrant the issuance of a protective order in a particular case, then that's when we issued it. And I would have to imagine.
Ma'am, can you please wrap it up? I'm sorry, we are very short on time.
That's all.
Okay. Okay. We will take these bills up again next week, and I'm going to read in some cards very quickly. We heard from Ms. Jessica Zimbelman opposing the bills, wishing to speak. Gabrielle Dressner from the ACLU of Michigan opposing the bills, not wishing to speak. Brendan Lanyon of Prosecutor Attorneys of Michigan, supporting the bills, not wishing to speak. Heath Lowry from the Michigan Coalition to End Domestic and Sexual Violence, supporting the bills, not wishing to speak. And Jess Averill from the Michigan Domestic and Sexual Violence Prevention and Treatment Board, supporting the bills, not wishing to speak. And before we move on to testimony on the power of attorney bills, we are going to quickly take some votes. We are going to take up Senate Bill 56 from Senator Chang. Supporting that bill, not wishing to speak, Brian Schoaf of the Detroit Regional Chamber. Supporting the bill, not wishing to speak, Cassie Thierfelder of the United Way for Southeastern Michigan. And supporting the bill, not wishing to speak, Kelly Doyle from the HIV/AIDS Alliance of Michigan. I will take a motion from Representative Devendorf to report Senate Bill 56 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards, Carter,
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
No.
Madam Chair, you have 9 yeas, 1 nay, 2 pass. Senate Bill 56 is reported with recommendation.
Thank you. I will now take a motion from Representative Hoskins to report. I'm sorry, before I do that, I will say that Heath Lowry from the Michigan Coalition to End Domestic and Sexual Violence on Senate Bill 236 supports the bill, does not wish to speak. I will now take a motion to report Senate Bill 236 with recommendation from Representative Hoskins. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards, Carter,
Yes.
Hope. Yes. Arbet,
Yes.
Devendorf,
Yes.
Hoskins,
Yes.
Cerniglu,
Yes.
Fink,
Yes.
Wenzel,
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. Senate Bill 236 is reported with recommendation.
Thank you, and I appreciate everybody's patience. We are now going to be hearing testimony on House Bills 4644 through 4646. Representative Hope, and we do have some witnesses here. I'm going to ask that everybody try to keep their testimony as brief as possible, no more than 3 minutes if at all possible. And Representative Hope, do you want to have some of your witnesses up there with you? Thank you. Please tell us about your bills.
Good morning. Thank you for hearing these bills today. The bills before you would enact the Uniform Power of Attorney Act here in Michigan. I'm not sure if everyone's familiar with the power of attorney. They're fairly common. They basically just let somebody else represent you, act as your agent. So although power of attorney is very common, they're different in different states, and that can create problems for the principals and the agents, as well as anyone who's asked to rely on that power of attorney, like a bank or an insurance company. Michigan doesn't have any general codification of the law of agency on power powers of attorney. It's just sort of a skeleton provision regarding durable powers. This is comprehensive, and by enacting this, we will join 31 other states who have passed this uniform law. And in addition, the law as drafted right now also creates a statutory form for a power of attorney, which would make it more accessible and very simple to use. In addition, because this is a uniform act, we would have the benefit, if we adopted this, of 17 years of case law from other states interpreting the language in this act. And I'm not an expert on this subject matter, and I'm happy to have experts here with me. I'm going to turn it over to Chris, and please introduce yourself.
Okay. Thank you, Representative Hope. I'm Chris Savage. I chair the ad hoc committee for the Probate and Estate Planning Council that has been reviewing this act since 2020. I did want to provide some testimony on this act, and starting with the power of attorney permits one person, as Representative Hope stated, the principal to appoint another to act as his or her agent. The powers of attorney are quite common and are already legal throughout the entire United States. But the governing law, the law governing their creation and use varies widely from state to state. This causes problems in our highly mobile society. We have individuals that have activities in other states. When third parties get involved in these multi-state transactions, particularly larger national banks and financial institutions, it becomes difficult when you're dealing with different powers from different states. So Michigan generally has no general codification of the law of agency concerning powers. It only has this skeletal, as Representative Hope pointed out, set of provisions, 5 sections, compared to the Uniform Power of Attorney Act, the uniform that we have proposed, which has 48. These are regarding durable powers that can be found in Michigan's Estate and Protected Individuals Code. This proposed act supplants those provisions with a comprehensive system of mandatory and default rules for durable as well as non-durable powers of attorney. The proposed act standardizes the law and improves upon powers of attorney statutes such as the current law that's found in EPIC by offering greater clarity and protections, which include it increases accessibility by providing an inexpensive method of surrogate decision-making to those with modest means whose property does not warrant pre-capacity planning utilizing such things as trusts and other estate planning tools, or post-incapacity property management by way of court-supervised conservatorships. By implementing this Power of Attorney Act, like I said, we expect that it's far more utilized to individuals, and it'll cut down on the use of or the need for conservatorships in our probate courts. The proposed act is a standalone act that provides an easy-to-use form, which Representative Hope mentioned. This form is simple. It has lots of cautionary instructions provided to both the principal and the agent with respect to its use. We expect that this form will provide principals and their counsel can safely and effectively use durable powers of attorney by use of this form. And importantly, very important for purposes of this act, is it helps prevent elder abuse. It does this it provides a detailed description of the agent's non-waivable fiduciary duties that it has to act to the principal. It explicitly limits the principal's ability to exonerate the agent's breach of that fiduciary duty. It expands access to judicial review of the agent's conduct, and it increases civil penalties when an agent for misconduct. It enumerates extraordinary powers, such as the power to make gifts on behalf of the principals that require explicit grants of authority. So the principal has to affirmatively state in the document whether certain exemplary powers, such as gifting, can be put into the act, which I think is very important. And it provides stringent default rules for the case in which the principal specifically grants the agent authority to make gifts, like I just mentioned with as far as the default rules. The proposed act expands Michigan's currently existing power statute, which which includes, these are some of the expansions. It provides new protections for third parties to whom notarized powers are presented for acceptance. This includes banks and financial institutions, added protections if they accept a durable power of attorney presented by an agent. As new protections for third parties who rely on these notarized powers. That's just protection for your banks and financial institutions and any other third parties that use these powers. So they're protected upon acceptance. This act imposes sanctions for unreasonable refusal to accept the notarized powers. In addition, it provides extensive and instructive descriptions of specific capabilities implied to various standards, grants of authority. Again, as I mentioned previously, there's 48 different sections, many of which specifically deal with real estate, tangible personal property, all sorts of other things that an agent might have to do on behalf of a principal. There's detailed instructions as to what those authorities are, which is something that's not included currently in our EPIC provisions. It has a convenient procedure for incorporation of statutory descriptions of the agent authority by reference. This gives the principal the ability to incorporate many different things just by reference to the statute. So we're not dealing with a power of attorney that's 50 pages long. The act can be incorporated by reference. So a lot of these provisions can be incorporated. It has default rules for determining the principal's incapacity. It contains default rules for the coordination of co-agents' authority and that of agents' successors. It has a coordination of the agent's authority with that of the court-appointed guardians and conservators that favor the principal's authority. It also has default notice procedures for an agent's resignation if that should become something that becomes necessary. It has clear rules on the termination of the agent's authority to act under a power and has explicit, valid favoring choice of law rules for multi-state conflict of interest rules, questions involving powers. What that means is that if a power is generated or executed in a different state, as long as it was executed validity in that state, then Michigan will recognize that. So that helps with our mobile society, as I had mentioned before. In all of these respects and more, this Uniform Power of Attorney Act proposal improves upon the current state of the law and the powers in Michigan. I also want to mention that this testimony is being provided by the Probate and Estate Planning section, which is a volunteer membership section of the State Bar of Michigan, comprised of 3,446 members. The Probate and Estate Planning section is distinct from the State Bar of Michigan. The prior testimony is provided on behalf of the Probate and Estate Planning section only, and not that of the State Bar of Michigan, Fraser Chubblecock, the Lau Law Firm, or Old National Bank. That being said, I just want to summarize by saying that we have been working and reviewing this act since in 2020. We have went over it extensively several times, many red lines. We have circled in and discussed these with constituency groups, including the Michigan Bankers Association, the AG's Elder Law Task Force. So we have tried to incorporate all of their comments into the revisions that we've made. We have made minor revisions to the Uniform Act, and the reason we have only used minor revisions is we want to stay consistent with the uniformity of the act to be able to take advantage of the jurisprudence of the other 31 states that Representative Hope had mentioned. So for that reason, we stuck to the extent possible to the Uniform Act.
Thank you very much for that comprehensive overview. And I know we have not only these other gentlemen up here with you, but we also have several other people that want to testify. So if anybody else up here has something to add, please keep it very brief.
I'm Mark Kellogg, and I'm the chair of the Probate and Estate Planning section. Just here for questions, so not any further testimony. And I want to thank Chris for her testimony.
Hi, I'm David Sprague. I am a member of the Probate and Estate Planning section. I also am a committee member over at the Michigan Bankers Association. I do not speak for them today, however. They have put in their own card. I only speak on behalf of the probate section. I will say, though, as the liaison between the MBA and the probate section, we have solicited a lot of information from the MBA. And we've taken a lot of the critiques that they have found, because a lot of the banks have obviously used this statute throughout their footprints. So we've tried to make it actually a little bit better but still not changing the Uniform Act so much that we will lose jurisprudence. I'm here for questions.
Any questions from the committee for these witnesses? Okay. Thank you for your testimony.
Thank you for your time.
And we have Amanda Murray and Judge Carl Marlinga. Okay. Judge Marlinga?
Mitch Albers from the Attorney General's office is with me as well. Contractor position. Mitch actually is an employee of the department. We're both happy to be here. Mitch, you want to say anything before I start?
No.
Okay. Madam Chair, I know that time is short, so I will keep it short. I've submitted the written testimony. By the way, Representative Wozniak, I want to thank you for all of the work that you did for the Elder Abuse Task Force in the past. We were all working for something more comprehensive, you included. This is more comprehensive. This is the bill that I think that we need in order to carry the water to accomplish what we want to accomplish. From the Elder Abuse Task Force point of view, and from my point of view, I was a prosecutor, a circuit court judge, a probate court judge as well. From my experience as a probate court judge, this is a dream come true. This is what we need, and I will give you an example as if I were sitting on the bench as a probate court judge, listening to cases come before me. Oftentimes, I would have a situation where a person would have a power of attorney. According to the Estates and Protected Individuals Code, I, as a probate court judge, am supposed to defer to the power of attorney because we want to respect everybody's individual autonomy and freedom and dignity. And if somebody has written a document saying that this is who I want to take over for me, if I ever need somebody to take care of me, I want to honor that document. However, I had petitions for guardianship and conservatorship before me specifically because a person held a power of attorney but found that it was functionally useless because every bank, every nursing home, every organization that they tried to deal with said, no, that power of attorney doesn't really match our form. We don't want to accept it. We want you to accept ours. And so here is our form. Of course, the person who is now alleged to be incapacitated doesn't probably have the power at that point to sign a new document. And so I, as a probate judge, knowing that I wanted to respect the person's autonomy and dignity and the choices that he or she previously made, was stuck with having to grant a guardianship or a conservatorship because the document that they were relying on wasn't being accepted. That's one scenario. Another scenario is that families would come and it would be pretty clear that if they thought about it in advance and had executed a power of attorney, they wouldn't need to be here for guardianship or conservatorship at all, except nobody really thought of it until it was too late. And now a guardianship or a conservatorship or both have to be granted simply because the process of planning for the incapacity was a little too tough because you'd have to go see a lawyer. They would be talking about writing up a trust. A trust was too complicated. The power of attorney would come into play. But sometimes you didn't even get it. So what we need, from the probate judge point of view and from the Elder Abuse Task Force point of view, is a document that offers the certainty. And in my written testimony, this is why I'm arguing so vehemently in favor of this. Because in my mind, it does four things. First of all, this bill, 4644, would standardize the form of a power of attorney, leading to its greater use. People would know you could use this, would use it, and of course, leading to its greater acceptance, which would reduce the docket on guardianships and conservatorships. The bill would allow for the recovery of costs and attorney fees if a bank, a nursing home, if some institution frivolously declined to use this. Now at least there's a remedy. You can say, well, wait a minute, you could go into court and you could get your cost and attorney fees if it were wrongfully rejected. The bill, and this is very important because sometimes power of attorneys have been used as a means of exploitation, the agent against the principal. The bill would subject an agent who uses the power of attorney to exploit the principal to, of course, the criminal penalties that are already there for embezzlement by an agent or conversion by an agent, but it would also provide for treble damages so that it'd be worthwhile to go to court not only to get back what the agent stole, but 3 times that amount in order to make it possible to get full justice if an agent went off the rails. And also, the bill would allow a wide range of persons to come into probate court to seek removal of an exploitive agent. Of course, the principal himself or herself, a guardian, a conservator, a person named as an advocate in a healthcare advance directive, an heir at law, which means the basic close family, or any beneficiary named in a trust, or the personal representative named in a person's will, or adult protective services, meaning the ability of an agent to use a power of attorney to exploit and wrongfully take advantage and convert money from his or her principal. The door would slam shut on that person pretty well because now we've covered the waterfront from all of the possible people who could come in and say, wait a minute, this looks like it's a voluntary power of attorney, but something has changed, something you got to know about it, and so it would allow the courts to step in if the power of attorney were wrongfully used, and that's something that's missing in Michigan law right now. Now, I realize that powers of attorney extend beyond the Estates and Protected Individuals Code. I mean, you can use it to sell real estate. There's a whole bunch of reasons you want to use them, but from the standpoint of a probate judge, we need this to cut down on the docket. I believe, by the way, that if this is passed, we will be reducing the docket maybe anywhere between 10 and 25%. If there's another bill coming up for to allow family members to step in so that we don't need guardians for health care decisions if a patient is unable to communicate with his or her doctor. If that is passed, we can basically reduce the docket probably about 40, almost 50% to take all of those cases that don't really need the ugly nose of government sticking its nose into people's private business. If we can get these bills passed, we are going to increase the autonomy, the dignity, the individual freedom of everybody in the state, but this is the first and biggest step towards it. Thank you.
Thank you, Judge. We are going to get kicked out of this room soon, and we have some other people that do want to testify. Do we have any questions for Judge Marlinga? No? Okay. Yes.
Yeah.
Representative Wozniak.
I just want to thank the judge for his testimony and all the work that he's put in on this also over the years. One question, though, taking consideration of the principal's privacy versus guardianships and conservatorships, and I think you alluded to the ugly nose of the government. How do you consider that, the privacy of the individual?
Oh, well, yeah. I mean, look, with this bill, we have people being able to take care of themselves now and in the future, and it's done without being spread on the public record in court, without everybody knowing everybody's business, and so this is a big measure to protect privacy as well. Thank you. Okay, thank you. Okay.
Thank you, and I also wish to express my gratitude to Representative Wozniak, as I know he's been heavily involved in doing a lot of this work. Thank you very much. Ms. Murray, and while you come up, I'm going to read some cards in. Chris Smith from the Elder Abuse Task Force and UPOAA Subcommittee has submitted written testimony supporting the bill, not wishing to speak. Kirian Marion from the Michigan Credit Union League, supporting the bill, not wishing to speak. And Alex Morris from the Michigan Bankers, also supporting the bill, not wishing to speak. Thank you, Ms. Murray.
Good morning. My name is Amanda Murray. I'm a practicing attorney here in Michigan. I've been practicing for about approximately 10 years with a firm that has been established for 24 years. We primarily focus on estate planning and elder law. As an estate planning and elder law attorney, I sit on the Elder Law and Disability Rights section of the State Bar of Michigan. So I am here today in that capacity on behalf of the Elder Law and Disability Rights section of the State Bar. That's often referred to as elders, ELDRS. The Elder Law and Disability Rights section is a voluntary membership section of the State Bar of Michigan, comprised of currently 1,129 members. The Elder Law and Disability Rights section is not the State Bar of Michigan, and the position expressed herein today is that of the Elder Law and Disability Rights section only. and not the State Bar of Michigan. To date, the State Bar does not have a position on this item. The elders section is comprised of many attorneys who also practice in elder law and estate planning. And our drive is to protect those who are vulnerable and the elderly in our state. We have been looking at these bills for a couple of years as well and discussing them with different sections of the State Bar. On June 3rd this year, our section took a position, which is that we support these bills in concept. However, we would like to see amendments to the bills. After our public policy decision-making body has 20 members, and after a vote, 15 members voted in favor of this position, 0 members voted against it, 1 member abstained, and 4 members did not participate in the vote. Our section does not support the bill as it's currently written for a few reasons, but I would like to focus specifically on 2 today. The first reason is that it's introduced as a standalone act. It's separate from EPIC. EPIC is the Estates and Protected Individuals Code. EPIC was designed and intended to be a comprehensive statute that deals with matters involving estate planning and disability issues, which include wills, trusts, and powers of attorney. This is being introduced as a separate act. When this happens, there could be greater potential for there to be conflicts between provisions. EPIC already includes numerous rules and definitions that address powers of attorney, and it's critical that these rules and definitions are consistently applied throughout the spectrum of disputes and interpretations that arise when dealing with various categories of documents, issues, and questions regarding interpretation and application of law. Therefore, it's our position that the Uniform Power of Attorney Act should be incorporated into EPIC and not a standalone act. We have seen this in Michigan in the past with the Michigan Trust Code. That too was a uniform act. However, Michigan decided to derive Michigan Trust Code and incorporate it and integrate it into EPIC. So it did not stand as a standalone code. Second, the elders' position is that there should be no statutory form. We strongly believe that a statutory form is doing the opposite of what the Act's goal is. We believe that a statutory form would encourage misuse of assets by making a safe harbor form readily available to the mass public. An unscrupulous individual could quickly and easily obtain a form instead of having to attempt to draft their own or contact an attorney, or with really being able to understand the great authority they're giving away. Having statutory forms readily available to be executed doesn't serve the elderly or the vulnerable because they lose the benefit of counsel. So naming an agent, which is somebody who has the authority to access someone's assets, that's grave authority. And before a document is signed, giving someone else that authority, it's very important that the principal understands the document that they're signing. And they lose the benefit of having an additional person interpret and answer questions when forms are readily available like that. We too have seen in our law another statutory form that's readily available, and that is a statutory will. Statutory wills, as practitioners, our section has seen that they fail because they're not properly executed, or perhaps the testator wasn't under the correct understanding of what something meant. However, wills come into play when somebody passes away. The Uniform Power of Attorney Act, a power of attorney is used during someone's lifetime. So it manages someone's assets during their lifetime and has the potential for misuse when those assets are needed to help someone sustain their standard of life or pay for their care. So in summary, the statutory form encourages misuse by a bad actor, increases the risk factor of elder abuse, provides a false sense of security to clients that they're covered. They have potential to cause non-statutory forms, so if you don't use the form, then your form won't be accepted. And they also must be changed over time. So just as an example, if you use a form, you can't modify the form, you have to use the form. The Uniform Power of Attorney Act, back in, let's say, 2006, when it was introduced, that form still does not include digital assets. So digital assets is something that has come up in the past decade or so that is included in most power of attorney forms for estate planning attorneys. And they speak to digital assets. For example, this form that's being introduced is silent to that.
Thank you, ma'am. And I'm sorry that I have to cut you short, but we are about out of time. I want to ask a quick question. Yep. Nothing in this prohibits somebody from hiring an attorney to make sure that they are doing everything correctly.
Correct.
But also there are people who do not have the economic means to hire an attorney, and this may help them at least take care of some of their business without the expense that would be incurred if they hire an attorney.
I would agree it doesn't prohibit, and that you wouldn't have to expend funds on consulting an attorney.
Okay.
I would offer that it encourages people to use it without understanding what it means, what some of the provisions mean. They don't have the benefit of counsel.
Sure. I look forward to some continued discussions on this. Do we have any additional questions? Happy to address some of those questions after committee, Representative Fink. If you do have questions, I would also encourage you to reach out to the bill sponsors. And seeing no other business before the committee, I do note Nicole Shannon from the Michigan Elder Justice Initiative supporting the bill, and she has submitted written testimony. If necessary, we can have you testify next week. But seeing nothing else, we stand adjourned.